On Tuesday, the Supreme Court heard in kind of an unusual hearing. It was a hearing by conference call because of the coronavirus pandemic.
God save the United States and this honorable court.
Dealt with two separate entities, one Congress, the other the Manhattan DA, who were both seeking Trump's financial records. And Trump in both cases has told them he doesn't have to give them to them. These are harassing inquiries, and that the president is immune to these sorts of inquiries.
Criminal process targeting the president is a violation of the Constitution.
He has refused to give them out, unlike every other presidential candidate in modern history. And he said various things at various times. You know, sometimes it was, I'm under audit.
Under audit. I'm under audit. Depends on the audit. I'm always under audit, it seems.
Sometimes it was, I've been told not to release them. Other times it was just like, I'm not going to release them.
The only one that cares about my tax returns are the reporters.
One case involves the House of Representatives, so that's the Oversight Committee and the Financial Services Committee. They've said things like, we want to find out whether Trump is influenced by foreign actors, whether he has any foreign funding he hasn't told us about, or, we want to use him as a case study to study how the American tax system, affects wealthy people.
I have some of the greatest assets in the world.
They're sort of prospective, which on the one level you can understand because since you haven't seen them, you don't know what's in them. The Supreme Court kept saying, well, you want these, why? What's the reason? What's the power you have that lets you see them? And the House's response was basically, we can investigate anything that we might legislate on. And so the Supreme Court justices said, well, that sounds like everything. You could write a law about anything. So what's the limit to your power?
In your view, there is really no protection against the use of congressional subpoenas for the purpose of preventing the harassment of a president, because the only requirement is that the subpoena be relevant to a conceivable legislative purpose, and you can't think of a single example of a subpoena that wouldn't meet that test.
The Manhattan District Attorney's investigation basically began with Michael Cohen. If you remember last year, Michael Cohen, Trump's attorney, said that he had paid off two women who said they had sexual relationships with Trump. He paid them off right before the 2016 election, and then he was paid back for that payoff by the Trump Organization, Trump's business. So Cohen went to jail for that on a federal charge, and the Manhattan District Attorney is saying, I want to find out whether New York state laws are broken. The Manhattan District Attorney seems to have a stronger case, partly because what Trump has asserted to defend himself here is a pretty out there standard.
You're asking for a broadness of immunity that Justice Thomas pointed out is nowhere in the Constitution. I'm not sure why he's entitled to more immunity for private acts than he should be for public acts.
Well, he's the President of the United States.
And the justices kept saying, is there a limit to that? Doesn't that make the president and those around him above the law?
It's also true, and indeed a fundamental precept of our constitutional order, that the president isn't above the law.
It's so hard to know what this decision could mean, even if they say, yes, both sides can have Trump's tax returns. They could get them, and there could be nothing untoward in them. They could get them, and there could be something really nefarious in them. They could get them and find something nefarious, and we, the people, wouldn't know about it until later. It's not like, if they say the Supreme Court rules against Trump's tax returns will be in the Washington Post the next day. I wish they would be, but I don't think they will.